Hi, everyone. Thank you for joining us for this installment of California Employment News, an informative video and podcast resource offered by the Labor and Employment Group here at Weintraub Tobin. My name is Nikki, and I'm an associate in the group, and I'm joined by my fellow associate, Tomiwa Aina. In previous CENs, we've talked about termination of the employment relationship. Today, Tomiwa and I are going to discuss documentation and paperwork employers will want to provide employees when the employment relationship ends. Please note, this is only a general overview and may not necessarily be exhaustive of all documentation employers are required to provide their employees. Tomiwa, did you want to start us off by talking about employees' final paycheck?
Yes, thank you, Nikki. So regardless of how the employment relationship ends, whether that's because the employee resigned from their employment, the employer terminated the employee, or there was a reduction in force, you will have to provide an employee with their final paycheck, including all earned wages, any accrued vacation, or paid time off. But note that the timing of when the employee receives their final paycheck can depend. For example, an employee without a written employment contract for a definite period of time who quits without giving 72 hours prior notice to their employer must be paid all of their wages, including accrued vacation, within 72 hours of quitting. Whereas an employee who gives at least 72 hours notice prior to their quitting and quits on the day that they have given in the notice must be paid all their wages at the time of their quitting. Similarly, employees who are discharged must be paid all wages due at the time of termination. Nikki, can you tell us generally about some documents that employers will want to provide to their employees?
Yeah, of course. I'm happy to provide some general kind of ideas of documents employers will want to provide. As we said at the beginning of the video, this may not be exhaustive. It's just some things you'll want to consider. So, when employees are involuntarily terminated, and by that we mean they're discharged or there's a layoff, the company must give immediate written notice to the employee of a change in the employment relationship under Unemployment Insurance Code Section 1089. Now, that notice must contain certain information. That's going to include the employer's name. Another thing you'll want to provide is the name of the person to contact at the company if the Employment Department Division, otherwise known as the EDD, needs further information. You'll also want to provide the employee's name, their social security number, the type of action, so whether that's a voluntary quit, layoff, termination, etc., and the date of the action. With this notice, you'll give a copy to the employee and then retain a copy for your records. And an employee must be given a copy of the notice no later than the effective date of termination. Employers can request that the employee sign acknowledgement of receipt of the notice, but you are not required to do so by law. Continuing on that onto the topic of discharge or laid off employees, the employer must provide the employee with Employment Development Department pamphlet DE 2320, which that will explain to employees their rights to unemployment insurance, state disability insurance, and paid family leave. This must be distributed no later than the effective date of that termination or layoff. Now, another thing to think about is with employers with 20 or more employees, COBRA, otherwise known as the Consolidated Omnibus Budget Reconciliation Act, rights notice and election form needs to be provided to employees who are participating in the employer's group health plan and to any of the terminating employees' dependents on the plan within the time requirements under COBRA regulations. And I know earlier we were talking about employees who have been discharged or laid off. This is for any employee where that termination, where the employment relationship ends. It's not limited to just discharged or laid off employees. For smaller employers, employers must notify any covered employees of their COBRA continuation rights. And we're talking about smaller employers, we're talking about under 20, right? So between 2 to 19. COBRA will be offered to both the terminated employees of small employees, like we talked about, who are participating in the employer's group health plan, and terminated employees covered under federal COBRA when their 18 months of federal COBRA coverage expires. One other thing to think about is that the California Department of Healthcare Services requires employers with 20 or more employees to provide the health insurance premium plan, or sorry, premium payment, otherwise known as HIP notice, DHCS 9061, to certain employees who would be covered under the program. Tomiwa, are there any other general documents or things employers will want to provide employees or think about?
Yes, so there are some items that employers should be considering. California Labor Code Section 2808B requires employers to provide to employees upon termination notification of all continuation, disability, extension, and conversion coverage options under any employer-sponsored coverage for which the employee may remain eligible after their employment terminates. Additionally, the Worker Adjustment and Retraining Notification Act, or the WARN Act, requires certain employers to give affected employees at least 60 days written advance notice of any plant closings or mass layoff. California's version of the WARN Act is broader in scope than the federal act and affects more employers. In fact, in general, employers are covered by the Federal WARN Act if they have 100 or more employees, not counting part-time employees who have worked less than 6 months in the last 12 months, and not counting employees who work an average of less than 20 hours a week. The Federal WARN Act also applies to employers who employ 100 or more employees who work together at least 4,000 hours per week. Now, under California law, employers who directly or indirectly own a covered establishment must give notice to affected employees of the covered establishment. A covered establishment is any industrial or commercial facility or part thereof that employs or has employed 75 persons within the preceding 12 months. Now, there is no requirement that the worker be employed full-time. So this means that both full-time and part-time employees will be counted towards California's 75-person requirement. This is, of course, a general overview of the WARN Act, and it's always helpful to talk to counsel on whether or not it applies to your company and your workforce. But that's it for now. You can continue to find our video series and podcast through the lelawblog.com or on the Weintraub Tobin YouTube channel. Thank you, everyone, for joining us, and we look forward to reconnecting with the next edition of California Employment News.